The broadcast is now starting. All attendees are in listen-only mode.
Hello and welcome to the DOE NOPR Potential Impacts and the Path Forward. Our webinar today is with TROUTMAN Sanders and FTI Consulting in partnership with InfoCast Events. Today I have with me Cliff Sikora, a partner at TROUTMAN Sanders, and Dan Larcamp, partner at TROUTMAN Sanders, and I also have Scott Harvey, consultant at FTI Consulting. So today's webinar is actually a preview of an InfoCast event called Projects and Money. And so at Projects and Money, you can gain insights from the project finance industry's leading forecasters as they share their view on market fundamentals and the commodity price outlook. And some of our featured speakers, other than TROUTMAN and FTI, are also EDP Renewables and S Power, NTE Solutions. And it'll be in New Orleans, so you should definitely check it out. For more information or to register, please go to infocastinc.com/projects-money. And again, that's infocastinc.com/projects-money. And before we get started today, I also want to let you guys know you can ask questions at any time during this webinar. And to do that, there's a Q&A box in the lower right-hand corner of your screen. You can ask questions all throughout, and we'll make sure to answer those questions if time permits. And so we'll leave that for the Q&A section later. Thank you guys so much, and now I'd like to welcome Dan and Cliff.
Thank you very much, Catherine. Appreciate the opportunity to speak. Appreciate everybody's attendance today remotely. This is a very interesting, controversial issue. It's one of the most unique developments that I think a number of us have seen in the past 10, 15 years in the business. When InfoCast asked Dan and I to do this event, we made it pretty clear that the controversial nature of the subject matter was such that we weren't going to be providing an opinion on it. That's not our goal. From the perspective of Dan and I going first in this webinar, our goal is to inform what's happened, what's happening now, what could happen next, and answer some questions as most from an agnostic perspective as possible. So we're not really here to take a position on the rule or any aspect of it, and to the extent we express an opinion, which again we're not trying to do, it's ours only. It's not the law firms, it's not our clients. And any of the information we provide to you today should not be considered legal advice. That's a standard disclaimer that you'll hear. Dan and I are gonna hit 4 topics pretty quickly, succinctly, and then turn it over to Scott. An overview of that. The first thing we're gonna do is we're gonna provide you an overview of the contents of the proposal from DOE to FERC. Second, what the statutory authority is in this very unique aspect of the law, Section 403 of the DOE Act. Third, we'll talk about some key dates and some of the questions asked by FERC staff. And then finally, we'll give potentially a little bit of insight into what may happen next. Catherine, next slide, please. Okay, so the DOE recommended a NOPR and directed that FERC issue a final rule on September 28, 2017. It was sent to FERC by Rick Perry, and the letter and proposal stated that it was directing FERC to issue a final rule requiring organized markets to develop and implement market rules that accurately price generation resources necessary to maintain the reliability and resiliency of the nation's power system. Perry directed FERC to enact a final rule requiring RTOs and ISOs to set, quote, just and reasonable rates for, quote, fuel secure generation, which most of the industry and the trade press is construing to mean coal and nuclear units. There was a specific proposal from the DOE that would amend a specific portion of the Code of Federal Regulations, in particular the Code of Federal Regulations that sets out the requirements for regional transmission organization and ISO transmission tariffs. So although what you have in the guts of this is pricing for resources and generation, it is being proposed as an addition, amendment, part of what a standard RTO ISO transmission tariff would be. In that respect, if you look at what FERC is or is not particularly required to do regarding this DOE directive, staff specifically, and we'll get to this in a minute, when they set out questions for commenters to use as a guide, they said that the Secretary had, quote, proposed a rule for final action. So that is what we have on the way FERC is viewing what DOE has sent to it. DOE's basis for the change is the loss and retirement of fuel-secure generation units, and the belief that competitive wholesale power markets are not adequately pricing those resources. FERC is directed again to establish what are known as, quote, reliability and resiliency rates, and that essentially is a cost-based rate with various words in the proposed rule talking about various types of costs. Sometimes the words are overlapping, sometimes they're subjunctive and conjunctive, depending upon how you read them. But the rates are known as reliability and resiliency rates as proposed, and they would be proposed for a set of resources called grid reliability and resiliency resources, which folks are calling GRRs. Yeah, let's go to the next slide. Okay, so in particular, there's been a good bit of discussion among folks informally and others formally in the past few weeks regarding the scope and applicability of the rule. In particular, there are criteria that the proposal sets out regarding what is a GRR, in other words, an eligible grid reliability and resiliency resource. And overall, if you kind of take it as a high level, it's got certain elements to it. We think the comments on the proposal should flesh out and give opinion on what specifically the proposal should and should not apply to. But on the face of it, there are some basic standard ways to read it. For example, I think we can say that it's fairly clear that the rule applies within RTOs and ISOs. So for example, although the Western United States has the EIM, it is not an RTO ISO approved by the FERC. Texas, for example, would also not be involved, not being in interstate commerce. Large parts of the Southeast, not an RTO or ISO. So I think we do know that it's resources that are within RTOs and ISO. One of the key differences, and this is shown by the great big red arrow that I put on the slide here, is that when the FERC issued or published the proposal in the Federal Register, as they're required to do, there was an errata that changed the words of the rule, and it was publicized as well by the agency who issued an errata. And the change was to clarify that the rule would apply to energy and capacity markets, or RTOs with energy and capacity markets, and to RTOs and ISOs that had a tariff with a day-ahead and real-time market, or the functional equivalent thereof, which of course is not specific. So for example, there are a number of folks who are of the opinion that this rule has limited applicability to, for example, PJM, New York, potentially New England, but perhaps not MISO. That will probably be fleshed out in more detail as the comments come in. In addition, the units as GRRs are required to provide, quote, essential energy and ancillary services. We don't necessarily have a definition of essential energy services. Ancillary services could be the ones that are required under the Commission's OATTs. Maybe not. We don't know. We don't know whether, for example, the intent was to exclude certain units that could not provide particular ancillary services. The 90-day fuel supply requirement, of course, is controversial. Folks have heard about that. Some people think that's too much, and that 90 days is a difficult amount of coal to keep on hand. The other questions involve, in particular, environmental compliance. What exactly does that mean? And being, quote, subject to cost of service. That was a specific question that staff asked. Each of these elements in particular is subject to comment, and staff has asked questions about them. And Dan and I, when we were speaking earlier today, I kind of likened it to a game of 52 pickup, which if you've ever played is you take a deck of cards, you throw it in the air, and you see where the cards land. So I think there's a lot of folks who kind of think they know where the cards land, but I'm just not sure anybody knows specifically where they will. Next slide, please, Catherine, and I'll turn it over to my partner, Dan.
Thanks, Cliff. I think we have to start with the posture that the DOE Organization Act is a bit unusual in terms of jurisdictional line drawing, if you will. I think it's important to remember when President Carter was the chief executive, we were, as a country, dealing with disruptions caused by the Arab oil embargo. So if looking at that, and with the Department of Energy that was a newly created entity in terms of the executive branch agencies, it is clear, at least to me, that the Secretary performs a special role under the DOE Act. He's allowed to intervene as a matter of right. Obviously, with respect to the authorities he's invoked in Section 403 of the DOE Act, he basically is given a very, very important role under the section. Under 403A, both the Secretary and FERC can propose rules with respect to any function within FERC's jurisdiction under 402 of the Act, and that includes obviously the authority to establish, review, and enforce rates and charges for the transmission and sale of electric energy under the Federal Power Act, which is what we're talking about under the DOE proposal. That seems fairly clear in terms of my reading of 403. Becomes a little less clear when we move down to 403B, which requires FERC to consider and take final action on any proposal made by the Secretary pursuant to 403A. The Secretary can set reasonable time limits for FERC's completion of the proposed action. In fact, the language is somewhat more specific. It basically says the FERC shall consider and take final action on any proposal made by the Secretary under 403A in accordance with such reasonable time limits as may be set by the Secretary for completion of action by the Commission on any such proposal. The Secretary has established what he believes that time frame is, which is 60 days from publication of the proposed rule in the Federal Register, which according to our count would be on December 11th of this year. This is, I think, in contrast to where FERC, under its own authority, under the Department of Energy Organization Act, institutes rulemakings to set general rules that will either establish or affect or relate to the transmission of electric energy or sale for resale of electric energy in interstate commerce, which is the bread and butter function of the Commission, I think, under the Federal Power Act provisions. Obviously, they have similar provisions under the Natural Gas Act. The DOE noted in their proposal that there was an extensive record that the Commission had already developed on the subject matter of its notice, and therefore it concluded, the Secretary, that the time limit for final action is adequate to receive and consider public comments. I will note that a lot of the record documents that the Secretary cited in his proposal are in AD files, which is administrative. They are not in rulemakings, but of course the Commission has the ability to take administrative notice of any matter, particularly those matters which are contained within its files. I think it may be fair to say that some of the questions that were asked in the earlier AD dockets are a bit afield of the Secretary's proposal. According to the conference reports on the DOE Act, Section 403 was designed to ensure that the Secretary had an opportunity to participate actively in FERC decision-making process and to assure expedited Commission consideration of regulatory matters. In fact, the Senate bill originally provided for the DOE Secretary to basically have an even broader role, but the final conference report, I think, established that the Secretary could initiate, but that the final determination would be by the independent regulatory body here, the FERC.
Yeah, and Dan, if I can make one comment, this is Cliff. I think the key takeaway when folks have asked, what is FERC required to do? I think the key is to look at the actual words of the statute, which say that they are required to consider and take final action. Now, in what time frame and what final action means and what would happen if they don't are all very interesting questions, but they are required to, quote, consider and take final action. Next slide, please, Catherine.
We're not going to go through all these. Just the prior precedent under 403. All I really want to point out is that in the first instance that it was invoked by the Economic Regulatory Administration by delegation from the Secretary, FERC acted on the requested effective date that the Secretary proposed. Second instance, FERC had determined the deadline for comments in its interim rule. They met that. The interesting one is the last bullet where action was proposed on June 1, but FERC didn't act until June 6th. I mean, that was 5 days later. So I don't know that that's going to matter much going forward, but I do think it demonstrates that there may be some flexibility.
Point being here also is that this is a very unique part of the statute. It really has not been tested in the courts, and it's only been invoked 3 times in the examples that we found. There could be more, but these are the ones we found. Next slide.
The bottom line, where we're at today, is that comments are due on the DOE proposal to FERC on October 23rd. Reply comments are due on November 7th. We expect, based upon our calculation of the time frame, but also on the General Counsel's comments up on the Hill a couple weeks ago, that the Commission will meet the 60-day provision, which would require action on or before December 11th. And as Cliff mentioned before, Arnie Quinn, the Director of the Office of Energy Policy and Innovation, issued a request for comments saying you don't have to answer any of them, but staff has a lot of questions on their mind that seem very similar to questions that we've seen both proponents and opponents of the NOPR raising, at least in the trade press.
Right. And I think that Scott will get into some of these issues more deeply, but we've kind of highlighted some of the more important ones and ones that I think are troubling folks, in particular, regarding the eligibility of units, with what types of resources should be eligible. Is there really a need for reform at all in this area? Is this something that's imagined by the DOE, or is there really the type of emergency exigencies that have been stated to be attendant? Can we go to the next slide, please? Thanks. So again, there are a number of very key issues, and Scott will go through some of them, but you know, how these cost of service type services are factored into the markets is, of course, a very interesting question. Are these units going to be favored over other units? What constitutes favoring? How will the rates be set, et cetera? We'll let Scott get into those a little bit more. Could you go to the next slide, please, Catherine? Thanks. So on a going forward basis, I think the chairman had a press conference on Friday and made some very interesting comments. He, as we noted here in the beginning, he held very much to the principle by saying that he thought that compensating baseload generation for essentially positive externalities was something that he thought was important. By the same token, he also said, as everybody else has said, that they don't want to, quote, blow up the markets. So those two things are kind of interesting. He also said that FERC may not issue a final decision within the 60-day time frame, although, as Dan pointed out, the general counsel on the Hill said that they would. He also talked about different procedural options that the commission had within it as arrows within its quiver in terms of what it would do next. And if you think about it that way, the chairman is looking at the potential of should he provide more notice, provide more comment? Should the commission look into this more deeply? And as Dan said, the record may be lacking. Do they want to get a broader record on it? That would be, for example, a tool applicable to them would be another proposal, another rulemaking set out for comment, more process. By the same token, they could, for example, set rates for hearing under 206 subject to refund and initiate that sort of an investigation on their own accord. There would probably be a good bit of nuts and bolts to figure out in terms of how that would work, but that is a tool within their quiver as well. I think, again, the interesting thing and the most important thing to keep in mind here is that the agency is, by law, required to act on the proposal, and it's required to give final action on the proposal. That's what the statute says. Now, interestingly, I think what's an untested question is, what happens if the agency doesn't? Who are the parties aggrieved, and what causes of action would they have? Dan, anything more before?
Well, particularly, you know, a lot of special interests in the industry have sought additional time, and the commission denied the request for extension of time. That doesn't mean that going forward, after the commission reviews the initial and reply comments, it may agree, as Cliff indicated, that they may want another round of comments, or they may want a technical conference before the commission. Things that they have used in the past, basically to help them with their policy determinations going forward. I just make one more point. Going back to 888, then I was on the team that worked on that for the staff. Looking at the ancillary services, resiliency is not on the list. And it really wasn't in the mind, at least of staff, when the commission was creating its open access regime. So I think we've got a lot of questions that hopefully will be answered going forward under appropriate measures of due process. And I think the most important things are some of the things that Scott will talk about from FTI Consulting about what others or some views on the NOPR may be today from an economic perspective. Scott?
Great, thank you. You want to skip ahead a little bit on the slides, Catherine? Okay, go ahead to the next slide. And the next couple slides, go to the first substance. The disclaimer is just, of course, that these are my comments, they're not any of my clients, and they're my individual opinions, not the collective opinions of the California Market Surveillance Committee. I want to start with a few, no, go back one slide. You skipped one slide too much, Catherine. I want to start with a couple of core observations. And Dan and Cliff have covered a lot of ground, and the FERC staff asked a lot of interesting questions. So I'm just going to focus on a few items that struck me as significant. And the first is, as Dan and Cliff noted, the NOPR only applies to merchant generation located within RTOs. And it's not just generation within RTOs. It's really important that this is only merchant generation. So that excludes a lot of generation, in most of the generation and most of the coal generation in the United States, because MISO and SPP are mostly cost of service. You've got cost of service states within PJM, and so you're almost and no coal in most of a lot of the other states in New England and New York. So you're almost talking about a NOPR that's about a few coal plants in Illinois, Ohio, Pennsylvania, Michigan, and Maryland, and maybe some merchant plants that are located in West Virginia. So it's almost the PJM coal NOPR. And the limited scope is striking, because if you look back at the DOE report, when it was looking at shut down coal generation, the DOE report was pointing to coal generation being shut down all over the United States, not just in these 5 states. And I don't see a table breaking it down by cost of service regulation and states like that in the report. But if you look at the figure 3.7 on page 21, it sure looks like a whole lot of the coal generation being shut down is located in cost of service states and outside RTOs. So that's striking in terms of the scope of this, and I'll come back to that in another connection in a minute. The second thing about that struck me is that it doesn't apply to nuclear plants, by my reading of item B, which says they have to be able to provide energy and ancillary reliability services, including but not limited to operating reserves. And nuclear plants can't provide operating reserves. So if we took this provision seriously and FERC didn't throw it out, it would mean that nuclear plants couldn't receive payments under this rule. And that's kind of surprising, since DOE talks about the shutdown of nuclear plants a number of times in the NOPR and in the DOE report. So one wonders what they have in mind, or if they understood that nuclear plants can't provide operating reserves. Item 3 is, one of the things they did not talk about in the DOE report, the dog that wasn't barking, is who pays for this. And I think this is really important to think about in connection with the first point, that this is really only talking about merchant generation in a few states. So how is this going to work in terms of cost recovery within an ISO like PJM that includes retail access states, cost of service states, and loads served by municipal and cooperative utilities? So you get issues like, are the customers in the rate regulated states within PJM going to be allocated not only the cost of the coal generation in their rate base, but also the costs of the retail access states coal generation? And then what about you might limit it and say, well, we'll only recover these costs from the customers in the retail access states within PJM, but how about a merchant generator that's located in West Virginia? Who does he get its costs from? And then are we going to recover these costs from the customers of municipal and cooperative utilities that happen to be located, they're located within a retail access state? And it seems to me that this selective structure of the NOPR's application to merchant generation is going to create pretty complicated cost and rate issues for FERC and PJM and MISO. And I wonder if these issues can be resolved within the structure of the DOE NOPR. It'll be interesting to see what FERC does with that. And then the fourth point is, again, a dog that didn't bark, is what are the resilient and reliability generation assets supposed to do? FERC staff has asked a number of good questions about implementation, but I want to focus on a really basic question of what do these resources have to do in order to get paid a return of and on its investment? Page 11 of the NOPR is some very vague language about generation relied upon to make the grid reliable and resilient, but nothing that could be, is operative as a standard for what they actually have to do. And this is important and complicated. You should think about, why are the coal units shutting down? Well, they're shutting down because their operation is uneconomic. Now, DOE is going to order the RTOs to pay coal unit owners a rate of return on their uneconomic assets. Well, the best response for the coal owner is to shut the plant down and take the money. So if you're actually going to get something for this, FERC has to come up with a performance obligation, and DOE didn't. And that performance requirement, and what FERC does, is really the the big question in terms of market impact that I want to get back to. So go on to the next slide, Catherine. The second topic I wanted to focus on is the rationale in the NOPR for the assessment of resiliency within RTOs and the need for action and action directed at RTOs and non-cost of service regulation. And FERC refers to PJM resiliency during the winter of 2014, but doesn't really talk of anything or make any comparisons about, well, what's the relative performance of organized markets, of merchant generation, of cost of service regulation in terms of resiliency and generation availability. And, you know, for one obvious comparison, we didn't say anything about how the New York ISO with a lot more gas-fired regulation did during the winter of 2014, where it actually had fewer issues than PJM. And then PJM also doesn't say anything at all about South Carolina electric and gas. And you might not be aware of it, but there actually was load shedding during the polar vortex in 2014, and it was by a regulated cost of service utility not located within an RTO, South Carolina electric and gas. So why are we focusing on merchant generation and RTOs when the reliability problem was with cost of service regulation located outside an RTO, and due in large part to the tripping of a large coal unit, the Williams unit? So this I think puts a burden on FERC, because since DOE hasn't actually done any analysis of the need for this kind of action or what's its scope should be, this lies on FERC to carry out this analysis. Now let's go on to the next slide, Catherine. And this is I'm returning now to the performance obligation that I mentioned on the first slide. And I think, you know, my reading is that DOE really hasn't specified any performance obligation for generation receiving the ratepayers, which means that FERC is going to have to do this. And what FERC does is going to be important and critical in terms of the impact on markets. And one approach you can see them taking would be to use a capacity market approach and say, okay, you're going to have to participate in the ISO capacity market in order to get this returned. But that could become a bottomless pit, because what, do you give them any amount of money, whatever is required for them to clear in the capacity market, no matter how uneconomic they are? And do they actually have to operate, or do they have to meet the capacity market requirements? DOE, FERC perhaps could require them to earn some proportion of their going forward costs in the energy and ancillary service markets, which would require them to put some value in the market. But how would you set the standard, given that these units are uneconomic to start with? You could envision, since we're probably talking about PJM, FERC could require these units to meet the pay for performance requirements. But since they're uneconomic, how uneconomic do they have to be? Suppose they can't satisfy the pay for performance. Suppose they basically would incur huge penalties because they can't meet those requirements. And how would it improve reliability to replace resources that can meet the pay for performance requirements with resources that can't? So one route for DOE would be to go down the capacity market approach, for FERC, but that has challenges. Catherine, you go to the next slide. So another approach would be for FERC to set up megawatt hour payments, production payments like we have for wind and some solar resources and RPS programs, where we'd subsidize the incremental output of these resources. And that would get them to produce output. But I'd hope that FERC wouldn't go down that route, because then we'd have an additional set of subsidies distorting outcomes in the market. And that and leading to additional resources being shut down. So all of these approaches in terms of performance and making these units provide some value, some reliability value, some resiliency value are complicated, because they're going to be difficult for FERC to implement for resources that are fundamentally uneconomic. So let's go on to the next slide, Catherine. So in light of these things, is the DOE NOPR and does what they proposed really provide a good starting place for FERC or not? And you could, in view of the lack of analysis of what actually contributes to resiliency and what we need and the lack of any performance requirements articulated, it seems to me that, you could argue that FERC basically needs to start over in considering these issues and start by defining what constitutes resiliency so we know what assets, what properties we're trying to acquire, then determine which resources, characteristics contribute to resiliency, then assess whether there's actually any problem with those characteristics in terms of utilities or other market participants within ISOs and utilities operating outside of RTOs, having appropriate incentives to provide the resources that provide those characteristics, which are a lot more, I think, than just having a fuel supply, because if you trip offline, if you're a slow starting unit, if you can't come online for 3 days when the weather changes, that doesn't contribute much to resiliency or flexibility. So there are a lot of elements that FERC could consider. Go on to the final slide, Catherine. So the final step then would be for FERC to think about what requirements need to be met by ISOs and non-ISO systems, and for ISOs and utilities operating outside ISOs and using either market or non-market approaches. And it doesn't seem to me that the FERC necessarily needs to specify the solution, because they could leave it up to the independent and non-independent operators to choose how they meet the reliability and resiliency requirements rather than specifying a particular set of generation resources. So that's my comments. So we've got some time for questions, Catherine.
All right. Thank you guys so much for your presentations today. Now let's take a look at some questions. All righty. We have a question here from Paul. He asks, can take action mean responding to DOE, SEC with a statement that asks the DOE SEC to reconsider, revise, and re-request for any number of reasons, legal challenges, and environmental concerns, etc.?
Well, I think what the question's going to, perhaps I'm wrong, is basically what does the language of 403B mean in terms of the FERC's responsibility? I think it is a largely unwritten slate at this point, but as Cliff indicated, there are practical problems if they don't adopt the final rule on December 11th. That will have to be considered down the road, presumably on appeal or further action by the Commission. Certainly, I think the chairman in his comments last Friday took a more expansive view of what the Commission needs to undertake to satisfy their responsibilities under Section 403.
Right. So if you take a scenario for a minute and sort of playing that out, and it's a very, very good question, but playing it out, again, the words of the statute clarify that what FERC is required to do is consider and take final action. Okay, now, it doesn't say, consider and decide. It says consider and take final action, which, if you read the section of the statute, seems to mean that there's a bit of a pole vaulting over normal due process. That said, I think that the question is well placed in that one could conceivably think of a situation in which FERC says, dear Mr. Secretary, we have considered and we hereby take final action on your proposal and we reject it. However, here is a new one. And it would have, more detail, it would be more well thought out, whatever it might be. Don't know whether that is a possibility regarding what folks are thinking about, but conceivably that could meet the terms of the statute, the requirements of the statute. Again, the difficult thing that lawyers in this field are looking at right now is who would be harmed by that and what cause of action would they have if the party believed that FERC did not undertake its responsibility relative to DOE. It's a very difficult question.
All right, thank you guys so much for your answers. We have a question here from Amir, and he says, how can FERC monitor compliance or performance to operation of essential services? Would this introduce potential market manipulations?
Sounds like a Scott question.
Okay, I'll try. Well, FERC would presumably have the RTOs set up the rules that would require, that FERC would determine what the rules were for performance, and then the ISOs would have to enforce them. But that's the whole question that I raised of how are the performance obligation be defined and what are the obligations going to be is pretty tricky, given the DOE gave no start to FERC. So FERC's going to have to come up with it on its own. And as I suggested, some solutions would be more have larger distortions than others, and some less so. But that's the aspect that would be very complicated from a market standpoint, is how to get some kind of performance out of uneconomic assets without distorting the market and driving other useful assets out.
All right, thank you.
I would just interject that this would not be if a proposal was adopted by the commission. This would not be the first instance that a market rule could be subject to manipulation that the commission had adopted. And obviously the commission has civil penalty authority of up to $1 million per violation per day for any violation of any statute, rule, or regulation of the commission. So they are not without authority. I mean, this is somewhat similar to going back to the nightmare days of the California crisis, where people were alleging that plants were shutting down inappropriately for purposes of raising price due to leaking, heat exchangers. The commission didn't have civil penalty authority there, but I will say that just because there's a market rule adopted doesn't mean that there isn't always the potential for someone to see a way around that rule to move price.
And by the same token, though, it's subject to review by market monitors.
Yes.
And then the market monitor report is, of course, potentially subject to FERC enforcement action depending upon the behavior.
Great, thank you so much. Please continue to ask questions during this time. We'd love to hear from you. I have another question here from Paul, and he asks, can the definition of baseload generation be challenged?
Well, very much so. I mean, when you say challenged, I think again, I think my 52 pickup example is probably on point. Dan and I both have been through a number of pretty significant rulemakings at FERC, and what you start off with is not necessarily what you end up with. I think that, as we all know, one of the hallmarks of the agency's actions revolve around what is and what is not undue discrimination. And there are those who have posited that regardless of what happens, the commission needs to be very careful about setting rates in this area or establishing processes and market rules in this area that don't end up being unduly discriminatory. And so the question that folks are posing along the lines that you did, Paul, has to do with, well, what about my resource? My resource can provide that same service. What are you talking about? Why is it particularly these services? There's been no record out there. In terms of the question of is it challenged, I think the thing is there is no definition at this point. I think folks should kind of look at what is out there currently as a ball of clay, a lump of clay, with the opportunity to shape it.
Great, thank you so much. We have another question here. What is the impact on CAISO and regionalization in the West?
Well, I'll venture an opinion, but again, this is not any CAISO opinion or MSC opinion, but first, the exclusion of cost of service states and cost of service regulation is very important because most of the participants in the EIM outside California are utilities subject to cost of service regulation and or cooperatives and municipals that are also covered by the FERC language. So it would appear to have relatively limited impact, but to the extent some of that generation got sold by the cost of service utilities that sold it to a merchant, because the merchant maybe could capture this subsidy, you get a potential expansion of the scope of this DOE action. And that's where the language about the EIM and having a day-ahead market and a real-time market or the equivalent, and with the schedules that are used for within the EIM, they're not coming out of a day-ahead market, but they are coming out of a day-ahead process. You know, would that be enough to get somebody under the camel's nose under the tent? That's a good legal question for these guys.
All right, thank you so much. Now we'll take one last question. If anyone has any last questions for these guys, just give you guys a moment. And if not, please feel free to contact Dan, Cliff, and Scott for after the webinar for any additional questions. Alrighty, I think we'll move on now. Thank you guys so much for all your questions today. And thank you, Dan, Cliff, and Scott, for your presentations. So now I just want to say thank you all for tuning in today. And as a reminder, you will receive an email with the recording of this webinar within 24 hours. And you're free to watch the webinar as many times as you'd like. And last thing, InfoCast's Projects and Money event will be in early January in New Orleans, so make sure to check that out. You can, for more information and to register, please go to infocastinc.com/projects-money. That's infocastinc.com/projects-and-money. And thank you again. Any last words from the presenters?
Not from Scott.
Alrighty, we'll end on that note. Thank you guys so much. Have a great day, and we'll see you next time.
Thanks,
Bye-bye.
everyone.